Once is happenstance, twice is coincidence. The third time, well, it's enemy action. Why do I bring this up? This famous line from Goldfinger, the James Bond novels, because one wonders whether or not the trend, which is becoming our friend in the United States Supreme Court, is brought about by the Trump Department of Justice. What do I mean? You're not going to want to miss this one, this exciting breaking news, which I think is a trend we've identified, and it's a good one, and it'll make you happy when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so we have exciting news here. As you know, the United States Supreme Court is going to hear the Wolford case dealing with the so-called vampire rule, which is the Hawaii law, and other states have adopted this as well, but Hawaii's law that says even with a concealed carry permit, you're not allowed to go into private property, even if that private property is open to the public. A grocery store, a gas station, a rest area. If it's private property, you cannot go into that, even if it's open to the public, unless and until you as a concealed carry holder get the express permission from the owner or the manager of that property. Which means for all intents and purposes in Hawaii, you can't go into any stores because they're not going to put a big sign up that says carry your gun on. We don't care. That's fine, because they're not even going to think about it. And who is the manager and who is the owner? And you don't even know half the time which gas station you're going to be going to until you start your trip, for example. So as a practical matter, they shut down all carry of handguns in the state of Hawaii by virtue of passing this law that says you cannot go onto private property, even if that private property is open to the public, without first and foremost getting permission from the owner or the manager of said property. Now, the reason why I mentioned this and the trend that is our friend is because the Wolford granting of cert by the Supreme Court has created a trend that is now causing Mark Smith and the Four Boxes Diner to possibly change our viewpoint on something. Specifically, I've been teaching all you guys here for the last year or two that as a general matter, the U.S. Supreme Court does not like to hear appeals or cases on what is known as an interlocutory basis. And an interlocutory basis means a case that is not yet completed. It's in the middle of the case. And they grant cert in the middle of a case before there's a final judgment, before maybe all the facts have been uncovered, before all the laws have been analyzed, before all the final decisions have been made by the lower courts. And the Supreme Court has historically not wanted to do any of this. However, as I said in my opening, once is happenstance, twice is coincidence, the third time is enemy action. That is a very famous quote out of the novel Goldfinger by Ian Fleming, the former naval intelligence officer for Great Britain back in World War II. And of course, Ian Fleming is the author of the James Bond novels. And that is a line that Ian Fleming wrote in Goldfinger, one of the most famous novels that, of course, became the famous movie of James Bond. Now, the reason why I bring up that once is happenstance, twice is coincidence, and the third time is enemy action is because we're starting to see a new trend developing in Supreme Court jurisprudence. And because you tune into the Four Boxes Diner to try to give you the reality on the ground as best as I can discern it, I am now identifying a potential new trend when it comes to the Supreme Court hearing interlocutory appeals on big-time, big-ticket issues. Do I have evidence of this? Yes, I do. In the last, let's call it since the start of the year, since it started 2025, there's at least 3 examples of what I'm saying here. And by virtue of 3 examples, that becomes enemy action. And by enemy action, of course, it's a metaphor for saying we've identified a deliberate, intentional trend. Okay? So in light of this, what are the 3 examples where the Supreme Court has taken a cert petition and granted it, heard the appeal on the merits where the case is actually on an interlocutory appeal in the middle of the case. Well, the first one occurred this spring. This is a very important case with a lot for us to learn from. And that case is the Skermati case. The Skermati case, which arose from the state of Tennessee. Now, the Skermati case was on a preliminary injunction basis when the Supreme Court granted cert in the Skermati case and decided whether or not transgender individuals had some sort of robust protections under the 14th Amendment's Equal Protection Clause. This was a case that really the transgender movement pushed to the U.S. Supreme Court because they had already lost in the U.S. Court of Appeals for the Sixth Circuit for all intents and purposes, and they decided to seek cert from the Supreme Court on whether or not minors who wanted to have gender reassignment surgeries or gender reaffirming care, whatever you want to call that, they argued to the U.S. Supreme Court to hear the case and grant cert on the question of whether or not the Tennessee law that basically banned all those sorts of behaviors and all those sorts of conduct by medical professionals and their minor patients that consider themselves to be transgenders. And the Supreme Court, despite the fact this was all on a preliminary injunction basis, the Supreme Court granted cert in the Skermati case and decided in the spring of this year, 2025, that transgender individuals do not have any kind of heightened protection whatsoever under the Equal Protection Clause, which frankly, if I could digress just for 10 seconds, was a terrible blow to America's transgender movement. It set them back arguably generations and certainly some number of decades, which illustrates my general point of the Second Amendment community should not be shoving to the Supreme Court bad cases that's going to give rise to bad law that actually undercuts the Second Amendment, which is why we want to be very careful in the Second Amendment community to make sure that the cases we push to the Supreme Court are ones that we're likely going to win and are likely going to set very favorable precedent that we in turn can use in lower courts to win for a right to keep and bear arms. We want to do the exact opposite of what the transgender movement did in the Skermati case in the spring of 2025 and before by shoving this case of Skermati to the Supreme Court, which actually turned out to be a terrible loss for the transgender community. And again, it's better to have no precedent than bad precedent at the Supreme Court level, because if the Supreme Court rules against you, you're stuck with it for decades and decades and decades, maybe even for the rest of your lives. Okay, so the first reason why I mentioned the Skermati case, in addition to really illustrating the point of don't push to the Supreme Court stuff you're going to lose on because it will be bad, the other critical point here is that was again on a preliminary injunction basis. It was on interlocutory appeal, meaning in the middle of the case. The Court of Appeals, the district court judges in Tennessee had not yet issued a final ruling, a final judgment. It was on a preliminary injunction fight, and the Supreme Court in Skermati granted cert and heard the case and ruled against the transgender movement there. So that's one example. That would be happenstance. Has the Supreme Court started to change their views? Maybe, maybe not when it comes to interlocutory appeals. Now, twice is coincidence. And guess what happened just a couple weeks ago? And that is the Lisa Cook case. Now, you remember the Lisa Cook case. She is a member of the Board of Governors of the Federal Reserve System. She sits on the FOMC, the Open Market Committee there, helping to set interest rates. And Lisa Cook is the woman who allegedly committed some sort of mortgage-related fraud by declaring supposedly multiple residences in multiple states as her primary resident, but you're only allowed to have one primary residence, and she allegedly had more than one, arguably because she wanted to get favorable terms on these loans, because banks often will give you more favorable terms and conditions and interest rates on something that's your primary residence, as opposed to other things which now start to look a little bit more like a commercial enterprise, like you becoming a landlord, for example. So as you know, the allegation was that Lisa Cook misbehaved, committed fraud, and Donald Trump, identifying this, used a relevant statute to say that he had good cause, for-cause reasons for firing Lisa Cook and kicking her Duped off the Board of Governors of the Federal Reserve System. Well, Donald Trump did exactly that. He terminated her position, but she sued in D.C., arguing that Donald Trump lacked the authority to fire her from the job and lacked the basis to fire her from the job because there was no good cause reason to fire her because it had not yet been proven in court that she had committed fraud in these mortgage applications. Now, the Supreme Court just decided about a week or so ago to grant cert and hear the Lisa Cook case, which is going to be argued in January of 2026. Again, the Lisa Cook case right now is on an interlocutory appeal. They're fighting over preliminary injunctions. They're nowhere close to a final judgment. Nevertheless, the Supreme Court just granted cert in the Lisa Cook case as to whether or not President Trump has a basis to fire her from the Federal Reserve System. So again, the first case is Scarmati, dealing with transgender minors in Tennessee, interlocutory appeal. Now we have Lisa Cook, whether or not Donald Trump can fire her from the Federal Reserve System, a second interlocutory appeal. And now, guess what just happened? You know what I'm about to say. The U.S. Supreme Court in the Wolford case, which up until recently, I basically been saying, no, I don't think they're going to take the Wolford case, not because it's not an important case, but because it's on an interlocutory procedural posture. It comes out of the Ninth Circuit Court of Appeals as an interlocutory appeal where the case is still pending. There is no final judgment in the Wolford case. So my prediction was I did not think they were going to take that case. There was an outside chance of it. It's a pretty straightforward case. We should win the case. There's a lot of reasons why you could take it, and the Supreme Court did indeed take it. But if I were gambling on the bet, or if I was betting on this, I would have bet that they weren't going to take the case. But it would have been sort of a closer call here. And the reality is I'm happy the Supreme Court granted cert. I always love it when I predict something that's kind of negative for the Second Amendment and good things come out of it. I would rather do that than say something fantastic is going to happen and be wrong there. I'd rather say I don't think it's going to happen for us, but then it does. I'm then pleasantly surprised. As well, I'm sure many of you are as well, pleasantly surprised the Supreme Court decided to take the Wolford case dealing with the so-called vampire rule. I think we're going to win it, and I think it'll be very favorable, unless, of course, Hawaii tries to moot the case out. But that's, of course, a topic of a separate video. So again, now we have 3 instances in super high profile, big time cases. The Scarmati case dealing with transgender minors, very big case. That was on interlocutory appeal. The Lisa Cook Federal Reserve System question, which really is actually raising whether or not the Federal Reserve System is allowed to be an independent fourth branch of government. The Supreme Court just granted cert to that on an interlocutory basis. And now we have Wolford again on an interlocutory appeal basis. That's 3 instances in the last several months of interlocutory appeals, which in the past would not be granted cert because they're of their interlocutory nature. And here we have all 3 being granted cert, which now makes me wonder, not that third time is enemy action, which is the quote from James Bond, but it is a question of whether or not this third time, these 3 examples give rise to a trend, which rather than be an enemy action like it was in the context of James Bond, it actually would be a third time is a positive development, a great trend, a favorable trend in favor of the right to keep and bear arms and the entire Constitution. So one does wonder whether the Supreme Court is kind of shifting gears here and establishing kind of a new sentiment or a new look and feel or a new trend, whatever you want to call it, indicating that they are now going to be more willing to take cases on an interlocutory appeal basis and decide them in a way that historically they would not have done so. Now, the only other point I want to make about this is that I want to read to you why the United States Department of Justice under Harvey Dillon and the Solicitor General John Sauer and Attorney General Pam Bondi, what they said to the U.S. Supreme Court in the Wolford case, where they explained that in the context of the Wolford case and the vampire rule, there was really no need for the Supreme Court to not take the case, that there was no reason for more percolation in the lower courts. There was no need for any kind of uncertainty in the lower courts. It wasn't going to preserve the role of the lower courts or any of these sorts of things the Supreme Court might consider in avoiding hearing a case on an interlocutory basis. And this is what the Solicitor General and the Trump administration had to say about why the court should take Wolford. And of course, these arguments prevailed because the Supreme Court did indeed grant cert in Wolford. But here's what the SG had to say in favor of the court granting the case, which they just did. The preliminary injunction posture in which this case arises should not deter this Supreme Court from granting review. The Court of Appeals did not decide this case in haste. To the contrary, it issued an 81-page opinion nearly a year after the Second Amendment petitioners had appealed. The court's decision also turned on the merits. The court explained that it need not consider the equities because the petitioners were not likely to succeed in challenging the default rule. And since the Court of Appeals merits analysis all but foreordains the final outcome, further proceedings in the lower courts would serve no useful purpose. This Supreme Court often considers constitutional issues in the context of preliminary injunction proceedings. No sound basis exists to treat the Second Amendment issues differently. Therefore, this court should grant the petition for a writ of certiorari limited to the first question presented. Exactly right. So you see what just happened here? John Sauer and Harmony Dillon over there at the Pam Bondi Donald Trump Department of Justice basically were saying to the court, look, you've taken cases on an interlocutory basis before. There's no reason not to do it in the context of the Second Amendment, even though you haven't done it before. But now's the time to step up and let the trend be our friend. And that is exactly what the Supreme Court did just here and just now. And again, this is a trend I wanted to identify for you now, because again, historically, the trend went away from interlocutory appeals. One wonders whether or not what I've just identified in this video is indicating a change in the blowing of the wind, a change in the direction of the wind in favor of perhaps freedom. But we will see, because the history of the future has yet to be written. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4Boxes Diner. Don't forget to subscribe both to YouTube and Rumble. I look forward to talking to you again real soon here at the 4Boxes Diner.
Orders up. Table 2A.